Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the recent decision by former Canadian Supreme Court Chief Justice Beverley McLachlin to accept a renewed term on the top court of Hong Kong. The Hong Kong Court of Final Appeal is the highest court in Hong Kong. Cases heard by the court are heard by 5 judges, including one non-permanent judge from another common law jurisdiction. McLachlin retired from the Supreme Court of Canada in 2017, just before reaching the mandatory retirement age. In 2018, she accepted the appointment to the Hong Kong court, and in 2021, she was appointed for her second term. Her role in the court is controversial. This is because McLachlin will be required to uphold a relatively new law in Hong Kong called the National Security Law, which has many civil liberties advocates concerned. Here today to talk about that law and McLachlin's role on the court are 2 legal experts, Professor Ryan Alford from the Boer-Alaskan School of Law at Lakehead University, and Jerome Cohen, professor at New York University School of Law, which actually happens to be where I did part of my law degree. Professor Alford, Professor Cohen, thank you both so much for joining me today. Professor Cohen, I want to start with you. Hong Kong's national security law, can you tell our viewers what it is and what it is that has civil liberties advocates concerned?
Well, this law was promulgated on June 30th of last year, and it bans, in very vague language, 4 categories of offenses. One is secession, another subversion, the third is terrorist activities, and the 4th, collusion with foreign forces. And people have been struggling ever since to figure out what conduct is included in these vague phrases. The problem is extended because the law claims to apply not only to conduct in Hong Kong and not only to Hong Kong residents, but to conduct anywhere by anybody. This is an extensive claim to overseas jurisdiction. And indeed, every program I speak at could be added to a possible accusation against me for violating one of the provisions of the Hong Kong law. And indeed, programs I've sponsored at the Council on Foreign Relations as recently as yesterday with distinguished legal experts from Hong Kong could be the basis for a charge that we have been colluding with foreign forces, that the Hong Kong people have been exchanging ideas with those of us on the outside. And perhaps even this program could be covered.
So you're suggesting this very program that we could potentially be charged under the national security law?
It depends what I say and what Professor Alford says, and perhaps even what you say, Christine.
It's shocking. I want to give Professor Alford a chance to get in here. Professor Alford, what are some examples of people, what they've been charged with under the new law? What are some of the details of some of those charges?
Well, the list of who's been charged is a who's who of leaders in the democratic movement in Hong Kong, and indeed of those leading figures in the legal profession who fought against the imposition of the national security law, which should be noted, was promulgated by the National Standing Council of the Chinese People's Congress in Beijing and imposed on Hong Kong. So among that, you have Martin Lee, who is known as the father of democracy in Hong Kong. You have leading figures in legal profession like Albert Ho and Margaret Ng. Yesterday, a barrister named Chow Hang Tung was arrested. She was arrested in her barrister's chambers. Allegedly, privileged solicitor client files were searched pursuant to a warrant issued under the national security law. In a chilling twist, she was due to appear today in court representing a client challenging the national security law. In fact, challenging the bail provisions that have been acknowledged by the Hong Kong Court of Final Appeal to violate the International Covenant on Civil and Political Rights, and which are also a blatant violation of the open courts principle, because it is currently illegal to report on bail proceedings under the national security law. And with respect to organizations, the Hong Kong Alliance was charged. An organization which is trying to challenge this law is itself now charged organizationally.
Welcome back to Canadian Justice, where we're discussing the Hong Kong Court of Final Appeal and former Chief Justice of the Canadian Supreme Court, Beverly McLaughlin's role on that court. Professor Alford, this national security law, obviously, as you and Professor Cohen outlined, very concerning, has a lot of people worried. But as I understand it, if Beverly McLaughlin is on that court, she would need to apply this law. So what are some of your concerns around a Canadian jurist doing that, and what might that look like?
Well, first and foremost, she will be serving on that court in that capacity at the pleasure of the executive. So the idea here is any judge who is going to sit on a case involving the national security law is on a list of judges that's been approved by the chief executive of Hong Kong, who is a Beijing-appointed politician. Secondly, it's quite clear, and this is from a decision involving Jimmy Lai's bail, that's the proprietor of Apple Daily, that the Hong Kong Court of Final Appeal, and indeed all the courts of Hong Kong, are required to apply the national security law, even though it is acknowledged it is contrary to the International Covenant on Civil and Political Rights. So in fact, you're not really enforcing the Constitution of Hong Kong, you're enforcing the Constitution of Hong Kong as it has been modified and interpreted by the National Standing Congress of the Chinese People's Congress in Beijing. So first of all, most jurists would not sit on a court if the case they sat on was chosen by the executive. I mean, they're effectively sitting on a state trial at the pleasure of the executive. And to be told that they can only apply the law as it's written, effectively with no actual possibility of constitutional review, they're sitting there as a figurehead.
Professor Cohen, sort of similar question to you. What might it look like to have cases involving, for example, repression brought before foreign jurists when there's this national security law?
I have to question your basic assumption. In what circumstances is it likely that any of the foreign non-permanent judges will be allowed to deal with any question under the national security law? It's not clear at all under Article 44 of the national security law that these people will play any role whatever. When Jimmy Lai's very important bail request came to the Court of Final Appeal, where were the national security judges from abroad? Where were the overseas non-permanent judges in that group? They weren't playing a role. And when other cases come to the Court of Final Appeal, how do we know that any of the foreign judges who decorate the court by staying on it will play any role whatever? They're only there as window dressing. They're only there to endorse a system over which they have really no control.
So Professor Alford, McLaughlin has defended her decision to reaccept this appointment by saying things like she can appoint judges to hear sensitive national security cases rather than having the China-anointed head of government make those appointments. Is this a reason to keep foreign judges on the court? How realistic is her assumption here?
Her response, and I'm going to be frank here, I found rather duplicitous, because she said that she had been assured by Chief Justice Andrew Chung that he was the only person selecting the judges to sit on national security law cases. That may be true, but he's selecting from a list and a pool defined by Carrie Lam and the executive. So to say, well, I received these assurances from the Chief Justice, well, it is clear under the legislation that that pool is selected by the executive, by Beijing-appointed officials. It seemed almost calculated to deceive.
The chief executive of Hong Kong is assisted by the number 2 official chief secretary, who until recently was head of security for Hong Kong. And he is playing the principal role in deciding who should be recommended to be on the list of the few judges allowed to handle national security cases. I had not heard until this minute that Justice McLaughlin had received this assurance from the Chief Justice. I don't think that's generally known. When people are told that Justice McLaughlin will have a role in selecting judges, it's preposterous to them. It may be at most she has an informal advisory role, but as Professor Alford says, the list really is recommended by the executive branch, and the Chief Justice can only select people who are on that list.
We will be right back after this commercial break. Welcome back to Canadian Justice. I'm Christine Van Geyn, and we're talking about the decision by former Chief Justice of the Canadian Supreme Court, Beverly McLaughlin, to re-accept an appointment on the Hong Kong Court of Final Appeal. Professor Cohen, there have been judges, other foreign judges, who did not accept these appointments to the Hong Kong court. What can you tell me about their resignations? Like, was it because of the national security law? And have they spoken out publicly about their decision?
They've generally been discreet. The Australian judge who withdrew said it was because of the national security law, but I have never seen him give any elaboration of that. The English Lady Hale, who recently withdrew, she made it clear that she was doing it for reasons of personal convenience. It's a long trip from London to Hong Kong. On the other hand, I just read today that she also said she was sure that at least commercial cases in Hong Kong were being well independently handled. That raises the whole question of the dual legal system, a dictatorial one for security and sensitive cases, and a democratic rule of law, liberal one for conventional commercial cases.
Now, I want to turn to Professor Alford for a minute, because there has been a lot of criticism of McLaughlin's decision to remain on this court. And there was even a motion at the Law Society of Ontario, I think you were involved in this motion, to have her decision condemned. What can you tell me about that, about general criticism, and what you think that motion might have achieved?
Well, I think it's calling attention to the fact, as Professor Cohen noted, that China is attempting to have it both ways. They're trying to say that with respect to commercial disputes, contract disputes, you're going to have the benefit of this common law system and top quality adjudication. But at the same time, by being there and operating in that role, it's giving people the impression worldwide that when it comes to national security, when it comes to criminal law, that Hong Kong will not become a totalitarian liberal order. And there's a quote I'd like to give you. Islands on which the rule of law prevailed were left amid an ocean of lawlessness, reassuring preserves in which traditional ideas of order continued apparently undisputed. And this made it harder to address the legality or illegality of the regime and to decide whether to support or oppose it. This is describing the German courts of the 1930s and the works of Joachim Fest. So this is the problem, is that in showing people that while there is some legality in Hong Kong, in certain types of cases, it makes it harder for people to actually grasp the growing totalitarian takeover of the city.
Professor Cohen, you've questioned whether foreign judges should continue to serve on the Hong Kong court at all. Can you explain what your concerns are and what role you think they're serving? At
first, for some years, until the national security law was promulgated, I supported the non-permanent foreign judges staying on the Court of Final Appeal. But in the last 2 years, it's become clear their staying on the court misleads the public, as Professor Alford has indicated. It gives the impression that all is right with the world. The most that any of them has said is the recent English judge who said, largely, the court is independent of the government, largely, and he didn't give any elaboration. But the question is, what is that? The judges, instead of making generalizations and abstractions, foreign non-permanent judges should be asking questions like, how are judges now being appointed in Hong Kong? What are the processes? What are the criteria? Who are the personnel that decide about appointments? Why is the jury trial abolished? What has happened to the privilege against self-incrimination? What has happened, of course, to the protection against antecedent behavior? What has happened to some of the most basic precepts? The presumption of innocence, the question of bail that Professor Alford mentioned. These are no longer basic concepts. Courts are not independent anymore. Their jurisdiction, their power has shrunk, even though their name continues to be used. And judges are under informal pressures. They're attacked daily in the Chinese and English language Beijing-controlled media. They are attacked by Beijing officials.
When we come back from this commercial break, I want to talk to you about the future of the court. Welcome back to Canadian Justice, where we're discussing the Hong Kong Court of Final Appeal and the decision of former Chief Justice Beverly McLachlin from Canada's Supreme Court to re-accept an appointment to that Hong Kong court. Professor Alford, McLachlin has said that the court, in defending her decision to stay on, she said it's perhaps the last democratic institution Hong Kong has that has not been challenged. Do you think that that is going to remain the case in the coming years?
No, and I find her statement absolutely puzzling because a court is not a democratic institution. It applies the laws that are written by democratic institutions, or in this case, a national security law, laws that are promulgated by a totalitarian institution. And Andrew Chung's reasons, the Chief Justice's reasons in the Jimmy Lai bail case said, we can do no other, even if this denial of bail and this bail system offends against international covenant, civil and political rights, and other instruments, we are bound to apply it. That's a correct statement of law. That's what courts do. So within this system, it is impossible for Beverly McLachlin to say, well, the formal adjudicatory mechanisms of the court haven't been abridged, but people are being brought before me, judges are being selected, all of these external pressures are being imposed, and then merely hide behind the fact that the justices still have some prestige or perhaps are allowed to wear robes at the pleasure of the Beijing government.
Professor Cohen, McLachlin has said that if she leaves, it would be a sign that people can't rely on the court for impartial rulings. So I think that begs the question, can they rely on the court for impartiality right now? And if there's only one foreign judge on it now, is that even enough to achieve impartiality?
Foreign judges will play no role in the Court of Final Appeal decisions. They are not patriots of the Chinese countryside. Only patriots can play a role in the adjudication of cases. Beijing has made that clear. If I were Justice McLachlin, I would give up. But to save her face, what she should do is appoint an advisory group to investigate the details of questions she obviously hasn't looked into. How are judges, all judges, not just foreign judges, being appointed in Hong Kong today? Who appoints them, by what processes? And who is allowed to handle cases, and what cases can't judges who they don't have confidence in handle? She ought to get some of the best barristers in Hong Kong who deal with these cases and who themselves are now increasingly under threat, to give her advice, not at an abstract general level of the rule of law, etc., but what's really going on in Hong Kong. That's a crucial thing, and she should know better instead of issuing, like the English judges have been doing, issuing very general statements that don't deal with the actual situation.
Professor Alford, we've got about 30 seconds. McLachlin said that she'll resign if there are changes to the court's independence. How much worse would things have to get before you think she'd resign?
I think the only thing that would trigger her resignation is mass resignations among the Hong Kong judges. That may be happening because of what's going on with the prosecution of the Hong Kong alliance, given that so many Hong Kong judges in the past had signed on to petitions condemning Beijing, putting them in a conflict of interest. So I think that's the only thing that would cause her to realize what's going on, is taking the cue from her fellow judges and justices in Hong Kong.
Well, I want to thank you both so much today for coming on and sharing your expertise. I learned a lot, and I won't be going to Hong Kong anytime soon. We've heard today about the recent reappointment of esteemed Canadian jurist Beverly McLaughlin to the Hong Kong Court of Final Appeal. Many civil libertarians and political observers have been concerned with repression being witnessed in Hong Kong, and crackdowns on mass demonstrations lead to huge fears about the future of the region. A new patriotic law now requires civil servants and democratically elected politicians to swear a loyalty pledge, and authorities can disqualify opposition lawmakers who don't pass the test. The Hong Kong police have closed down and now raided the Tiananmen Square Museum and detained 4 members of the group who ran it. This is all being done under the national security law, a law that Justice McLaughlin will now be in a position to apply as a member of the court. Is Justice McLaughlin's role in the court being used as cover or window dressing for an anti-democratic laws? Or is the court the last bastion of democracy against the encroachments of China? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.